Hello, and welcome back. You are listening to Passing the Baton. I'm Jared Hight from Tracktown Law, and today we are discussing why a last will and testament belongs on every adult's to-do list, whether you're 18 or 80. A quick disclaimer. I'm a lawyer, but listening to this podcast does not make me your lawyer. This does not create an attorney-client relationship. For advice relative to your specific needs, please contact a licensed attorney in your state. Let's begin with a story. Taylor is a 24-year-old software developer in Corvallis. She owns a Volkswagen, a growing Roth IRA, and a beloved rescue dog named Maple. One rainy night, a distracted driver runs a red light. Taylor doesn't survive. She never drafted a will because, in her words, I'm not old and I'm not rich. Under Oregon's intestacy statute, everything she owns passes to her divorced parents who haven't spoken in 10 years and live in different states. Maple ends up in a crowded shelter until relatives argue over who will take the dog. Taylor's modest assets, around $50,000, are eaten by legal fees, shipping costs, and duplicated funeral arrangements. Now, imagine an alternate timeline. Taylor spends one lunch hour with an attorney, signs a simple will, naming her best friend as personal representative and guardian for Maple, leaves the Roth IRA to her younger brother, and designates the car to her mom. Total cost, about $800. Total peace of mind, priceless. That's the power of a basic will. A will performs 4 critical functions. First, it appoints a personal representative, the quarterback who gathers the assets, pays the debts, and distributes inheritances. Without that appointment, the court chooses, often the first relative to petition, regardless of competence. Second, a will directs who gets what. Sentimental items, Grandpa's pocket watch, a first edition novel, create the most litigation because the law treats them as personal effects without specificity. A will removes guesswork. Third, a will can create testamentary trusts. For minors, a trust guards inheritance until a responsible age, for example, 30 instead of 18. While still funding education. Fourth, a will nominates guardians for minor children. Oregon judges almost always honor that nomination unless clear evidence shows harm. So, despite this, 67% of Americans do not have an estate plan in place. Why is this? Let's start with the favorite dodge, I have no assets. Look around your living room. Your phone holds thousands of irreplaceable photos. Your laptop stores years of family history, and that savings bond grandma slipped into your birthday card is still earning interest. Sentimental value often outruns dollar value, and without a plan, those treasures can end up in a yard sale box or a recycling bin because no one knew who should take them. The second excuse sounds reasonable until you test it. Everything I own is joint. Joint ownership only covers what is joint right now. Refinance your mortgage, open a new brokerage account, roll over an IRA or a 401k, and the paperwork may default to your name alone. The minute that happens, the asset falls outside joint rules and into probate limbo. A joint title today is not a guarantee for tomorrow. Excuse 3 feels comforting, but is just as shaky. My spouse will get everything anyway. That only works in the simplest first marriages. Blended families, stepchildren, or even a tragic accident where both spouses died together can shatter the assumption. Without clear documents, state law or a judge decides who steps in, and the result may leave the surviving spouse sharing assets or even fighting with children from a prior relationship. Finally, many people feel that estate planning is depressing. In truth, it's an act of love, not morbidity. When you organize your wishes, you're writing a thank you note to your future family. I cared enough to make the hard choices so you won't have to. The plan you sketch today will spare your loved ones from courtroom stress and second guessing at the hardest moment of their lives, and that's a gift worth giving. Proper execution is the linchpin that turns a stack of paper into a valid will. Under Oregon statutes, the testator, that's you, must sign or direct someone to sign while 2 disinterested witnesses watch, understand what they are witnessing, and then sign the document in the testator's conscious presence. Disinterested means the witness is neither a beneficiary nor married to one. Using your eldest child or their spouse invites needless litigation because any gift to a disinterested witness can be reduced or avoided entirely. Although Oregon allows a notary to add a self-proving affidavit, that notarization is in addition, not a substitute. The two-witness requirement never goes away. When we conduct signings, every client signs in blue ink so an original can be distinguished instantly from black and white photocopies. The client then initials the bottom corner of each page to confirm that nothing was slipped in or removed after signature. Once the final signature and witness attestation are complete, we staple the pages once, permanently. Removing that staple later can raise questions of tampering, so we advise against ever unstapling for photocopies. Instead, we immediately create a high-resolution PDF, store it in an encrypted cloud storage, and email view-only links to the executor and the alternate executor. This ensures that if the physical will is lost in a fire or a safe deposit box mix-up, an electronic copy exists to guide the court during a lost will proceeding. Finally, the original executed will goes into a fire-resistant safe or a safe deposit box, and we document its exact location in a short memorandum signed by the client and delivered to the fiduciaries. These seemingly small formalities are what prevent expensive court challenges later. Skip them, and the best drafted estate plan can fail at the very first hurdle. Updating is easier than drafting from scratch. We can add a codicil for small tweaks or restate the will for major overhauls, but life changes, marriage, divorce, birth, death, big moves, always trigger review. While Oregon automatically revokes gifts to ex-spouses, property that's titled jointly with right of survivorship does not change, so you must update your deeds after a divorce. So, what's the cost? A simple attorney-drafted will, a power of attorney, and an advance directive package at Tracktown Law runs $800. Compare that to probate delays, creditor claims, and family disputes that can devour tens of thousands. If you're ready to put your wishes into writing, please visit tracktownlaw.com for personalized guidance in Oregon or Idaho, and turn your good intentions into binding instructions. In the next episode, we're going to demystify the Oregon probate process from start to finish.